ladies and gentlemen, thank you for joining us for another in the Beverly Hills Bar Association's litigation section series of war stories. I know that you're going to want to hear everything that our guest today has to say. He is Roman Silberfeld. He is a trial lawyer with a truly impressive record of courtroom success across many challenging disciplines in the field of complex civil litigation. So he has handled business, high-tech matters, product liability, professional negligence, mass torts, with an emphasis on multi-state, multi-party, and class action litigation. And he is not only meticulously dedicated to and successful in meeting the demands of the courtroom, but he is also a very courteous, easygoing fella. He's got one of the best dispositions you are likely to find in a courtroom. And he is a special friend of the Beverly Hills Bar Association, having been the recipient of our inaugural Excellence in Advocacy Award in February 2011, where he was joined by retired Chief Justice Ronald George of the California Supreme Court in being recognized by Beverly Hills Bar Association. So, Roman, it's good to see you again. Thank you for being with us.
Mike, it's good to be with you.
Ladies and gentlemen, I want to let you know as a housekeeping matter, your materials were sent about an hour ago with the reminder email for this program. And you should take a look at the materials. They include the very thorough order of Judge Phillips denying Disney's motion for judgment and new trial, which goes through all of the details of the case very thoroughly, more so than Roman and I will. Also, MCLE certificates will be emailed to you within 24 hours of the conclusion of the session. So, Roman, first of all, the case is Celador International versus Disney, correct?
Right.
And how did that case come to you?
Well, we became involved when a group of, I think it was about 16 lawyers, joined our firm in 2009. And I only remember that because I was sitting on the floor of my hotel room attending the inauguration of President Obama in January of 2009, negotiating the deal terms of this group coming over from the collapse of what was then known as the drug firm. And the people who came over were the entertainment litigation group from that firm. And along with them came quite a number of cases, including celebrities.
And they had filed the Celador case a number of years before. The case was initially filed in 2004, is that correct?
I think it was 2004, Mike. Yes, but they had litigated the case fully for, I think it was almost 5 years, and actually had a trial date in, I think it was May of 2009, when some intervening events happened, but we can talk about that. But there was a trial date pending in the Celador case when the group joined us in February of 2009.
And you were pointing at trial in May of 2009, but then something happened that postponed the trial for more than a year. Is that right?
Right. What happened was that the case was filed first in the state court and was removed to the Central District in Los Angeles. And the judge, who was Florence Lee Cooper, many of the people on this call will know who Judge Cooper was, passed away suddenly. And the case was in limbo for a little while and then ultimately was reassigned to Judge Phillips in Riverside.
So at the time that the case came to Robbins Capital, what remained to be done to prepare the case for trial?
I think pretty much everything was done. You know, all the witnesses have been deposed. The expert work had been done. The experts had been deposed. And so it was really just sort of in the can, ready to go. And somebody had to read the file and try to understand what was going on. And that's sort of for me.
Sorry for intervening again. Roman, if you could please lower either your speaker volume or maybe your microphone sensitivity, because we're getting echo from you.
Well, so Alex, stay with me for a second. If I turn this microphone off, tell me you can hear me now.
We cannot hear you, but maybe turn down the speaker volume.
Okay, let me see how I can do that.
Look, let's jump into this thing.
Okay.
Was expert discovery done when you started handling the case, Roman?
It was, the depositions were complete and the reports were complete.
Oh, okay.
But we did have an opportunity to sort of fashion how the experts would testify, and we had an opportunity to change part of the focus of the case. Yes.
So tell us what the facts of the case are in brief.
Well, in short, Celador is a company composed of a group of, I think it's 8 or 9 individuals. They created the concept for this game show called Who Wants to Be a Millionaire. They created that concept. It first aired in the UK. It was a huge, huge hit. They licensed that game show concept to, I think, about 110 countries in the world. When ABC came calling, ABC wanted to acquire the rights to the program in the United States rather than simply license it. And that resulted in an agreement between ABC on the one hand and its affiliates and Celador on the other. But the clients essentially were individuals who were the creators of the television concept.
And as I understand it, and reading Judge, let's move then. So the case, after Judge Cooper passed away, the case was transferred to another federal judge in the Central District, correct?
Right, Judge Phillips, who was then, she's since become chief judge and even retired from that position, but she was sitting in Riverside. So the case basically transferred out to Riverside.
And so you then had to try a Hollywood accounting case in the federal courtroom in Riverside, correct?
Right.
So what did you think about, did you have any idea about how that might be different from trying it maybe in downtown Los Angeles?
Well, certainly you have a completely different jury pool out in the Inland Empire than you do in downtown Los Angeles, even though the federal court jury pool net, even downtown, is fairly wide. You know, they draw people from lots of places. But even drawing those people from lots of places, a lot of people have excuses for not serving because they have so far to go. Our jury pool and our jury in the Celador case was composed of people who lived, you know, Ontario on the west, Temecula on the south, Indio on the east, and I think Victorville on the north. So the composition of that jury was really different than a downtown LA jury one would otherwise expect. And
you were going into trial asking for more than $200 million in damages, correct?
279 to be exact, yes.
So that was a big number, and maybe one that most of your jury pool had never seen or even conceived of, I would imagine, huh?
That was clearly one of the big challenges, to have jury accept the idea that someone could be damaged to that magnitude. And, you know, we tried to express the damages in smaller numbers, like on a per episode basis. But at the end of the day, when you add it up and you do the math, it's still a very, very big number. And that was a challenge.
Looking at the papers as I have to prepare for this interview, I have a sense that the Hollywood accounting issues in this case had a lot to do with the different entities that were involved on the Disney side. Is that fair?
Right. That is, in fact, sort of the quintessential definition of Hollywood accounting when multiple companies are owned by the same parent. They have no incentive to deal at arm's length with one another. And when they fail to deal at arm's length with one another, what naturally happens is that a profit participant who has an interest in the profits doesn't get those profits because sometimes the way these relationships are designed, there never is any profit. In fact, there are ever mounting losses accrued over time, notwithstanding the success of the television show or program. And that is, basically what Hollywood accounting has.
Who were the players in this one? Who were the players on the Disney side?
On the Disney side, it was ABC was the network. Buena Vista Television is a company that actually produced the program, made the show. And Buena Vista Television would pay a licensee to ABC, which owned the rights to the show. And that was not a fair market value transaction on a per episode basis because it didn't matter. Both Buena Vista Television and ABC were under the Disney umbrella. And so what happens in these accounting cases is that all manner of costs and expense are loaded onto a program such that it never shows a profit. And so the profit participation that my clients expected when they signed the deal and granted the rights was automatically designed by the studio to never occur. I mean, it was just an illusory promise completely.
So one of the ways, as I understand it, that your defendants did that was that ABC assigned to Buena Vista the rights to the show, and then Buena Vista returned the license rights, but held rights to various other profit streams without returning them to ABC. Do I have that right?
That's right, including syndication and first run syndication.
And so, but Celador's participation was limited to the money that ABC saw. Is that how it worked? So that there was money disappearing essentially to BVT of Buena Vista Television that Celador never participated in, correct?
Correct.
And that and that BVT and Disney and ABC never accounted to Celador for, because as I say, it just disappeared into the coffers of BVT. Is that right?
Right. Yeah, and that was largely the ad revenue from the value of the advertising from having the #1 show on television for 3 straight years.
Right. So maybe I got it wrong. Maybe the Celador's participation was in the rights that BVT held, and ABC was earning the advertising revenue in which Celador couldn't participate. Is that that's
both.
right?
Yeah.
Yeah. Okay.
The agreement with both ABC Television and BVT.
Right. So the trial began in May of 2010, correct?
June 1 of 2010.
And how long the trial last?
5 weeks.
Going in, did you have a theory of the case that, because obviously I've been practicing for longer than I would care to admit, and I find the facts kind of difficult to follow, as I just demonstrated in the last 5 minutes. How did you think that you would, I don't know, boil it down, present it in terms that a jury would understand?
I suppose the central objective of a jury trial lawyer is to tell a simple story, if possible. It may not be possible, but if you can distill down the story from pages and pages of contracts and thousands and thousands of emails to a simple story, that can be, not always, but can be a winning formula. Our simple story was that Celador entered into this transaction expecting to share in the profits of the success of the show. it was prepared to take a risk and it's less money up front. Everybody understands that. To share in success if it's success. And the Disney position was, you made the deal you made, and we do business the way we do business, and so the cash you got up front is all you get. You don't share in the profit because there never are any. And one of my favorite trial exhibits to the case was we prepared a chart. Show was still on the air in syndication, first run syndication. When we went to trial in 2010, it had premiered in 1999. So we had an 11-year timeline. And what it showed was that according to Disney and according to their accounting methods, the show continued to lose money year over year over year. It lost $2 million in the first year. By the time we got to trial, the show had lost $80 million for the studio. And Disney actually got up and asked the jury to believe that that was true.
Hard to do business if you lose $80 million over 11 years, isn't it?
Yeah, I don't think any of us would be in business, would we?
So that's one of the issues that comes out in Judge Phillips's order denying the motion for new trial, that again, I commend you folks to read if you have the time and the inclination, is that a lot of Disney's defense appears to have been that this was sort of business as usual in Hollywood, and that Celador either didn't understand it or knew that that's the way it was going to be, and this lawsuit was sort of sour grapes after the fact. Is that an accurate sort of summary of their defense?
Yeah, I think that is their position, and we sued on 3 separate theories. The most important was not breach of contract or accounting necessarily, although we prevail on both those claims, but we sued for a breach of the implied covenant of good faith and fair dealing. And we did that, and that's not a decision I made. That was made a long time ago by my predecessors. But it turned out that the jury really hung its hat on, and its verdict was that Celador had been denied the benefit of the bargain.
And what was the tip-off to Celador that there was money being withheld? I mean, were they getting accountings that showed 000, or how did they even know in the first place that there was money there that they were entitled to that they weren't getting?
It was they were getting quarterly statements from Disney as required by the agreement. But they were seeing a disconnect between the ever-mounting losses, because the statements continued to show quarter over quarter of losses. It was hard to reconcile that with 2 things. One, it was the number 1 show on television. Its ad revenue was through the roof. And as it turned out from information we discovered throughout the case, that Disney internally thought it was the greatest thing since sliced bread too.
Yes, so you're getting at the internal communications that during the term of the negotiation of the contract, I think, right? So who were
and afterwards?
And who were the best witnesses that you recall even now for your case?
Well, I think my favorite witness is a witness who never showed up.
Who's that?
And that was Michael Eisner, who was the former chair and CEO of the Walt Disney Company. My second favorite witness was Bob Iger, who did show up because he was ordered to, and we can talk about that more story if you wish. But it was clear that to the jury when the case was done, that there was a complete disconnect between what Celador was being told on the account statements and what Disney actually believed and was earning from this valuable property.
So at the time of that the lawsuit went to trial, Michael Eisner was no longer the president of Disney. Is that correct?
Yes.
Did you take his deposition during discovery?
I can't really remember. It's been that long, but I don't think he was deposed, but he was on our witness list because Judge made clear to us before trial that no documents were coming to evidence without a sponsoring witness. And so in order to get certain key emails in, we put Eisner on the witness list.
And what were the key emails that you wanted to get in through Eisner's testimony?
Well, one of the defense themes in the trial of the case was, yes, who wants to be a millionaire had been, an early success. It really faded quite quickly. And therefore, that explains why it didn't make any money. That's the argument. We had a series of emails from Michael Eisner to his board, the board of directors of the Walt Disney Company, in which he said, this is the greatest thing that's ever happened to ABC. This is more important than the Monday Night Football deal that ABC made, in which they paid something on the order of, I think it was $2 billion to NFL for the rights to Monday Night Football. So hard to contrast that with what was happening in the accounting statements and what was being said in court.
And the Eisner emails were while the show was on the air, while supposedly it was losing popularity.
Yeah, exactly.
Okay, so you put Eisner on the witness stand, on the witness list, but not on the witness stand. Why not?
Right. This is a bit of a lengthy story, but I'll make it as short as I can. We were required to give 48 hours notice of the time we wanted a witness to appear from the other party. So I wanted Michael Eisner to come and testify on a Monday. And on Thursday, more than 48 hours before, in the evening after court or the afternoon after court, I went to opposing counsel and I said, Marty, we want Michael Eisner on Monday. And he said, well, I'll look into it. Great. Let me know. On Friday, in the afternoon after court, I was told, gee, sorry, Mr. Eisner won't be able to testify on Monday. He's out of the country. I said, oh, really? Where is he? And he says, well, he's in Italy. And I said, well, it's going to be hard to get him back here by Monday. I understand that. When did he leave? And I wasn't given an answer. And in fairness, I think maybe my opposing counsel didn't know the answer at the time. And so we pressed the question of when it was that Mr. Eisner had left for Italy. Required court intervention. Disney was ordered to answer that question, and we got the answer. The answer was he had left the day after I had requested his appearance on the following Monday.
Now you mentioned court intervention, but it wasn't court intervention in open court, was it?
No, it was over again by phone with Judge Phillips at home. And so when it became clear to everybody that a game had been played, that Eisner had left so not to testify about the emails that I just described to you, Judge Phillips said, well, turned to me and said, what is it you want by way of a remedy? And I said, well, I want those emails to come in without further authentication or any proof of admissibility. And she said, so ordered, they're in. Is there anything else you want? I said, yeah, I want Bob Iger here on Monday morning to testify in place of Eisner. And she ordered that. And so on Monday morning, in place of Mr. Eisner, Mr. Iger came and testified.
And how did you use Iger's testimony then?
Well, so I didn't want the Eisner documents to just come in and be able to use them in closing. I wanted them to have life. And the way to give them life was to show them to a witness, and that's what I used Iger for. And I was able, since they were already in, I was able to put the emails in front of Iger, who obviously was there at the time. I think he had moved from being president of the network to being president of the company, the parent company. So he was clearly there, and knew about all this, and he knew about Who Wants to Be a Millionaire. So this was not anything shocking or new to him. And so I showed him the Eisner emails, and I had him read from the Eisner emails, especially the good stuff for my side. And he said, well, let me explain what those emails really mean. I said, go right ahead. And he said, well, Michael Eisner is a very emotional man. And he says things that he doesn't really mean. And he didn't mean all that stuff about how important the show was to the network. And I said, okay, well, thank you for that. How about you, Mr. Iger? Do you tend to be more emotional or more reserved? He said, no, I'm a completely different sort of person than Eisner. I'm very reserved, very businesslike. And I said, let's look at some of your emails about the television show, because we had those. And Iger's emails were as effusive about the value of the show as Eisner's had been. And so we got all those emails in directly through Iger's testimony, and he was a little embarrassed, frankly. Not that he gets embarrassed easily. He was a little embarrassed to have to, have read to him his own words.
So it actually worked better for you, it sounds like, not to have Eisner on the witness stand, and to.
Well, we'll never know for sure. But lemonade out of lemons, yes, we did.
Good for you. Good for you. And then ultimately, of course, the case went to the jury.
Yeah.
Now, there's a question that I have about the calculation of the license fee that Buena Vista paid to, or I guess that ABC paid to Buena Vista. How did that match the cost of producing each episode?
They were equal. So the license fee equaled production cost, which meant that there was never going to be any profit from the license fee calculation.
Because Buena Vista also showed a loss due to the production costs in the very amount of the license fee that got paid, correct?
Exactly.
So they canceled each other out.
Never.
Okay, all right. So that's one example of the sort of Hollywood accounting that we are talking about.
Yeah. But and the key to sort of the whole concept of Hollywood accounting is that in a fair system, the licensing fee would be based on fair market value, not on some sweetheart deal between affiliated entities. That's sort of the point.
Right. Okay. So, were there any weaknesses in the case that you were concerned about going in?
Well, not really a weakness, but a concern was it was a complicated contract that had, many features to it. It had multiple claims. There were not just profit participation claims, but there were merchandising claims, accounting claims, and trying all that to a jury is a challenge. I don't really regard it as a weakness so much. I think the amount of damages being sought was potentially a concern to me because it was such a big number. So those were the things that I was concerned about, but it was a big fight. The post-trial, the thing lasted another 3 years. We didn't get paid till 2013. It was a relatively straightforward breach of the implied covenant case. I mean, fundamentally, Celador was denied the benefit of its bargain. It was, and the jury had an easy time with that.
Yeah, it sounds to me like breach of the implied covenant was actually more important than breach of contract, because from what I pick up, the contract seemed to have seemed to support Disney's interpretation. That would be just my interpretation of the contract versus yours. That was Disney's defense, essentially, was we read it this way and Celador read it the other way, but we complied. It's really the breach of the implied covenant, because that allows the jury to take into account what the reasonable expectation of Celador was and whether Disney had tortiously denied that, correct?
Right. And part of the defense in the case was, and this was of concern to me too, that, any number of people testified saying, well, this is just the way it works. What are you getting excited about? I mean, there's just nothing here. And it's at least possible, if not plausible, that a jury could have bought that argument and said, well, this is just the way Hollywood works. It's, a different sort of deal. It's not GAAP accounting. It's not even accounting. I mean, it's something else. But a jury might have bought into that as a concern, sure.
So when you chose the jury, did you use a consultant?
I did. I used my longtime consultant, who's a woman by the name of Judy Rothschild, a psychologist and sociologist and jury consultant that I've used for 25 plus years.
And the jury, how many were on the jury?
Well, this is interesting. Federal juries are 6-person juries. We had 6 people selected as a jury, and then because of the length of the trial, panel 4 alternates, with the expectation that over time we'd lose 1 or 2 or maybe 3, but never fall below 6. Well, it must have been an interesting case to this group, because at the end of the trial, we still had all 10 jurors. It was kind of neat from the standpoint of them paying attention, but not so neat because of the rule that says when you submit a case to a federal jury, all the jurors who are left deliberate and decide. And so we actually had to prove the case not to 6 jurors to get a unanimous verdict, to 10. And that's what we did.
Wow. Okay. So that's even more challenging. What
There's an argument for 3-person juries, by the way.
Exactly. What were you looking for in jurors, or what were you trying to avoid? Did you have a profile in mind?
I haven't ascribed to the profile theory in a long time. My view of jurors is if people can be fair-minded, not that they don't have biases. They do, you do, I do, we all do. But if they can set their biases to the side and listen attentively, and they have, a reasonable level of smarts, get them through the story and get them to the evidence. If they can do those things and they don't have obvious faults such that you'd have a cause challenge, I'm good with jurors. I really am. So there wasn't a particular profile. I think we were looking for people that were, reasonably intelligent, maybe had some business experience, but there wasn't going to be anybody who had Hollywood business experience.
Right. And you might not have wanted to have it.
Well, that's also true, I suppose.
So there's a question in the Q&A here that is a kind of a high level question. William Morris represented, well, first of all, William Morris Agency was the agency that packaged the show, correct?
Correct.
And there was litigation regarding whose agent William Morris was, right? It was Ben Silverman who was at that time in the London office, correct?
I think Ben was either in London or New York. Yes, I didn't trial the case. But yeah, there was a real question as to who the agency represented, whether it was the studio or the talent.
And one of Disney's defenses was William Morris negotiated a deal that Celador wasn't happy with. Sue William Morris, right?
Right. That's right.
And what was Celador's contention regarding the role of William Morris and whether they had any liability for the bad deal that ended up?
I would say there was smoke but not fire about that. There was certainly a tinge, if you will, of conflicted representation on the part of the William Morris people. There were a number who testified, not just Ben, but other people testified from the agency too. And this again, I mean, this whole idea of a packaging commission was something completely foreign to my clients. I mean, they didn't know what packaging was. And it's interesting, present day, the recent settlement between the Writers Guild and some of the agencies will outlaw packaging commissions effective, I think, next year, as I read the news stories. Anyhow, it was certainly a relatively powerful argument that Disney made that, Celador was represented by sophisticated representation in the people from William Morris, and it was on them if they made a bad deal. Yeah, that is the case.
And the numbers were renegotiated after the show became a big hit, I think, as well. But my reading of the paperwork is that the renegotiated license fee was between the Disney participants, correct?
Correct.
So nobody ever came. Now, did Celador go to Disney and say we want to redo the numbers?
Not during the network run. I think the lawsuit and the claims process began when the auditing of the statements began. That was after the network run.
And that was when Celador discovered that Disney and BVT had renegotiated the license fees between themselves without notifying Celador. Is that right?
As I recall it, yes, that's right.
Yeah, that sounds like a pretty incriminating fact for Disney. So the question that we have is why, in the ordinary course, the questioner asks, why wouldn't the packaging agent simply go in and renegotiate the license fee to avoid all the problems? And I think we've answered that question. That there was a renegotiation, but between these related parties on one side of the deal, and Celador was not a part of that.
Was that, and probably one other feature, which relates to just how lucrative packaging commissions are to agencies. I mean, they are enormously lucrative because if, let's say in the case of Millionaire, if William Morris could bring to Disney not only the idea and content for the show, but also bring the host, which happened to be Regis Philbin in the first iteration, and the package. If representing them separately was worth $1 each, representing them as a package was worth $10. I mean, it was an enormously profitable venture for William Morris, which would completely disincentivize them from biting that very hand that feeds it.
Right.
I'm trying to answer the question more directly, maybe too directly. I don't know.
Exactly. So their client, Regis Philbin, might get fired as host and they would hire somebody else because William Morris had rocked the boat, as you suggest. Yeah. That is a problem that we all recognize now, thanks to the WGA lawsuits that have proceeded.
Right.
Yeah. Okay. All right. Well, after 5 weeks of testimony, I guess the case went to the jury, right?
Yep.
Where did?
That's right.
At what point? Iger testified in your case in chief, or?
Yes.
And then how long did your case last?
I think we tried the case for about 3 weeks of the 5, and then the Disney case took about another 2 weeks.
And then did you present a rebuttal, or did it go to the jury after closing arguments pretty much?
I think it pretty much went closing. Or there might have been some cleanup of, a few issues, minor stuff, but nothing of significance in the jury.
And then the jury had the case to deliberate, and you said all 9 jurors or 10 jurors deliberated together?
Yes.
And it was, and you guys had to get all 10 of them to go your way. Was that right, or 7 out of 10?
No, 10 out of 10. A unanimous civil jury in the federal system. Yes.
Right. Okay. Well, it was a challenge. So when the jury, when did the case go to the jury? Do you recall?
Yeah, I know it was before a weekend. I just can't remember the exact time. And I know that July 4th fell somewhere in there. And the jurors had asked for an extra day or so off. They deliberated for 1 full day. They asked for a couple of days off around the 4th of July that year. I forget what day that was. And then they came back on the first court day after the holiday weekend, because I knew it included a weekend, and reached a verdict pretty quickly on the first morning back, within an hour. And
what was that verdict? At that point, you took 3 causes of action to trial. There was breach of contract, breach of the implied duty, and I guess there was an accounting, which was not jury tried. Were there any other, aside from the breach of contract and the implied covenant, were there any other jury tried claims?
The accounting claim went to the jury only for the amount. They
Okay.
found that there was $2-something million of, accounting errors that made.
Okay. All right. So now we had a question, not to, I mean, everybody knows that you won. We had a question about the Don Johnson verdict, and you and I had talked about that before.
Sure.
So Don Johnson had sued the producers of Miami Vice, is that correct?
Right.
And it was a similar claim for unpaid rights payments, correct? Because I guess he owned a piece of that.
Yeah, he had a profit participation right, and he sued, and that case was tried, I think, Santa Monica in Superior Court.
More or less the same time as your case was being tried, right?
Well, both verdicts were announced the same morning.
And the verdict in the Don Johnson case was smaller than Celador's verdict, I think, correct?
It was, but it was still, I think it was $25 million, and then it increased to something in the 40s with, interest and such.
And at that time, that was the largest Hollywood accounting verdict on record, correct?
For about 2 hours, yes. That's how long the record stood.
And the verdict that the jury handed down for Celador was 269 million, is that correct?
We asked for 279 and they clipped us $10 million. So we got $269 million, and then there was judgment interest added on top of that, another $50 million.
So the total judgment then was 319 million?
319 and change, right.
Okay. And what was Disney's response?
They took an appeal after post-trial motions. The appeal resulted in an appellate decision in the spring, I think, of 2013. And the judgment of the court was affirmed in all respects, and Disney paid the judgment in full.
So how did this case affect your career? I mean, at that time you were obviously we're talking about 2008, 10 that the case was tried. So you were a pretty well established litigator at that point. Did you see any impact of the case on your career afterwards?
Well, I never tried a entertainment industry case before this. This was the first one. There was certainly plenty to learn about the nuances of that industry. But I suppose I sort of became known as doing these kinds of cases after that verdict, for sure, not before. And I think it can never hurt to get a nice big verdict and keep it, which is the more important part.
And is the case still the largest? Is the case still the largest verdict in a Hollywood accounting case, to your knowledge?
I believe it is. I haven't seen a bigger one. I think there's a couple out there now that have claims, they haven't been tried yet, but that have claims that might eclipse that verdict. But no, I think it remains to this day the largest verdict in the entertainment industry.
Yeah. And you mentioned opposing counsel, and you said the name Marty. Who was the opposing counsel?
Marty Katz, Mullen, a very talented lawyer.
Yeah, and all right, well, good. I am going to open the floor to questions. We have some in the Q&A. What was the biggest surprise in the case? Were there any, or did it go pretty much, the trial go pretty much the way you expected?
Well, I think the biggest single surprise was when we were told that Eisner wouldn't show. I think that took some thinking and strategizing that we had anticipated. We thought, people would follow the rules as set by the court, and they just chose not to, but I think they paid a price for it.
Yeah, clearly. Well, I think most of the questions we have answered here. Who did you try the case with?
I had a team of colleagues from Robbins, two of whom had been at the prior firm, Marcia Harris and Bridget Taylor. And I tried the case with my then partner, Bernice Kahn. So we had a terrific trial team, split up the witnesses and, gave everybody a chance to talk on their feet a little bit. It was a great experience. It really was.
So all four of you tried the case together. You were all in the courtroom at the same time, more or less?
Yes, every day. Yeah.
And out in Riverside, did you stay out there, or did you drive back and forth?
No, we stayed at the popular Mission Inn. It's such a, goofy place. But yes, that's where we stayed. And then we would simply walk to court every day. We walked like 3-4 blocks to go to the courthouse every day.
Yeah, the Mission Inn is a great place. If you haven't been there, you need to go. Okay, here's a question we have from Jay Doherty asking whether the contract had express provisions allowing self-dealing and disclaiming fiduciary duty. Was there a disclaimer of fiduciary duty in the contract?
There certainly was a provision in the contract that no fiduciary relationship was created in the contract by reason of the contract. There was, I'm trying to remember whether there was arm's length language in the agreement. I can't remember that. I'm sorry, Jay. If you call me later, I'll try to get you the answer to that question by looking back at the contract, but I don't remember that one.
But I know it was an issue at trial that Celador knew that Disney intended to have the production handled by Buena Vista.
Yes.
And there was another entity as well. There was BVT and Disney, and there was a third entity.
Yeah, there was a third that was a distribution arm only.
Yeah, distribution. And so, I mean, I think we talked about that the that Disney's position was the contract provided for these different participants, and there was no there was disclosure of the relationship, which was what made the cause of action for breach of the implied covenant of good faith and fair dealing so important, because arguably the contract would have allowed Disney to do the things that it did. It just it was really in this case it sounds like the breach of the implied duty was the smell test, so to speak, that allowed the jury to award the damages and do justice.
Right. You know, if I could share, you know, one sort of heartwarming aspect of the trial, because I think the audience might be interested in this. You remember I mentioned that the jury went out and deliberated, and then they went away for a couple of days for the holiday. And then when they returned on the first court day after the holiday, they announced their verdict in like a half hour. And when the case was all over and we spoke to the jury members, one of the things I asked the foreman was, what was that all about? Why did you announce your verdict a half hour after you came in? Why don't you just do it last week before you left for the holiday? You would have been done. He said, well, there's a very interesting story around that. He said, well, we sat in the jury room. We actually reached a verdict, before we went away for the holiday. And I said, okay, explain. He said, we thought this was a very important case. And we felt like the parties deserved to have us think about this and dwell on it and sleep on it for a little while. And that's what we did. We went home for the weekend. We all reconsidered our positions and our thoughts and our verdict. We came back on the first morning after the holiday and we said, are we all of the same mind? Everybody said yes. 10 people said yes. And that was the verdict. And that took about 15 minutes. And the importance of that story, I think, is to have faith and confidence in the jury system. That's the story there. It has nothing to do with who won and who lost. It's always nice to win. It always hurts to lose. But to have faith in the system that we have, that story is one of my favorites. And it is just emblematic of why we have jury trials.
Yeah. Yeah, I agree with you. That is really an endorsement of the jury trial system. I want to tell people who've got these more sort of technical questions, like Todd Levitt and Jay Doherty, who asked the questions about the agent's role and the provisions of the contract. Take a look at your materials, because you will see, as I said, particularly the order of Judge Phillips denying Disney's post-trial motions goes through all of those issues that you folks asked about in great detail. It's highly educational, and it created a situation where when Disney actually appealed, their appeal was, or it wasn't really an appeal, I think. I guess it was an appeal, but it was of the order denying the motion for a new trial and the motion for judgment after verdict. And so the Ninth Circuit's opinion was not even published. And it's only like 6 pages long, and basically says the Judge Phillips did it exactly right. Her order is correct. So really, the story of the case for somebody who's interested in the nuts and bolts part of it, as an attorney, is in Judge Phillips's order denying the post-trial motions that Disney filed. That, as that turned out, that was what all the shooting was about, and it sort of stopped after that. I mean,
right.
Yeah.
Well, that and I should, in fairness, give a shout out to Robin Meadow at the Grind Martin firm, who represented us on appeal and did a masterful job of distilling these issues down even further, so that when the opinion came out, it was the opinion that you referenced, Mike.
Yeah. No, it was clear that the appellate counsel must have framed it absolutely perfectly because the Court of Appeal just moved it straight through without any tinkering at all. All right, well, folks, we started a little late. And again, I apologize for the technical difficulties. But I think unless you have anything more that you'd like to say about the case, Roman, I think we probably have all gotten a great deal out of hearing from you.
Well, it's a pleasure to be with you all. I wish we were live and in person, but we're not. Mike, thanks for having me.
Always a pleasure, Roman. I enjoyed talking with you, and I really learned a lot. Ladies and gentlemen, the program materials are in the chat so that you can click on it if you haven't already gotten them. I encourage you to look at them. They are really an education in this area of the law. They go through a lot of very technical issues. And would you say, Roman, that this case had any impact on these kind of standard practices of Hollywood accounting?
Well, I don't know for sure. I mean, it's certainly, encouraging to others to try their hand at this because it shows that the case can be won. And listen, the Don Johnson verdict helps too. Other verdicts and results since have kind of proven that point. But I do know for a fact that the form of contracts and agreements has changed rather dramatically over time. And, we'd like to think that we had a small part in making that happen for the better.
Well, thanks, Roman. Thank all of you, ladies and gentlemen, for your attendance. I hope that you found this worthwhile, educational, and enjoyable. Have a great weekend, and we look forward to seeing you again on another Beverly Hills Bar Association program. Thanks again. Bye-bye, everybody.
Bye-bye.